Oh man,
Well,
I'm
it is
telling
the
you.
first of the year. Isn't the first day of the week Monday?
Oh man. If it feels like it should be a Monday, kind of
Or
like
at
that
least
Groundhog Day thing going on.
right, at least the first day of the work week.
Right. Well, I hope everybody out there isn't too awfully hungover, because if you are, sorry about your hangover. That's my New Year's love wish for everybody.
Yep.
Oh man, I'll tell you.
Happy New Year. This is the year of 2020 vision in my
You
mind.
you got that right.
This is this is going to be the year where we get to see things clearly. Whether you like it or not, the truth is going to come out, and especially with dealing with government and all the bad actors in government.
Mhm. Well, I can tell you right now, uh, when I get into doing the little bit of an opening, I prepared a short of a short opening for the show, just because I was horsing around with vendor stuff today, and I had some time on the computer, and so I decided I'd play a little bit, and I put some stuff together, and I'll be sharing that here shortly. Let everybody get settled in and relaxed, and whatever stuff you guys are going to do, I'm going to get this shared, by the way. So, we know the drill. Don't start without me. Don't start without me. Okay. Okay. I'm not. Ish.
Ish.
So,
Yep,
that's
but
pretty
we're
much the
here.
standard.
It's the first of the year, and dang it, I didn't even have a shot or anything for the new year,
Oh, I did.
unless you consider coffee shots.
Yeah. Yeah. No, let's see. That's my once a year, whether I need it or not. That's just the facts of law. Just say,
Mm-hmm.
speaking of law of creation. Oh man.
Yep.
Get this to, hey, why won't you work? My audio still coming in okay?
Yes, sir.
Okay. Okay, good. I was seeing the
5x5 over here.
little doodad on the screen wasn't moving there. So yeah, I see it moving now. All right, good. Oh, yes. Feels good to just and that is where we are now. Let's see, where are we as far as viewership goes? Got all these pop-ups showing up on the screen over there. So now we have to wait for those to disappear. And while I'm doing that, I guess I'll fire up YouTube. All right, good. And come on, YouTube, play nice. Gonna go over some stuff that has. I actually did it in November, and well, you guys will get the idea when I share it.
The new and improved. Oh,
Right?
got to start off with something new for the new year.
Yeah, well, it's there we go. I have to break my comment down on YouTube because there's only a lot of certain number of characters, or it won't let you comment
Yeah,
on YouTube.
I know. That's like Twitter.
Oh, I
Can only,
know.
can only do so much.
I feel like one of the kids texting, I got to figure out how the hell am I going to put that in a short form where everybody can understand it. Start reading, uh, newspaper want ads. How do they put that crap in shorthand anyway? So
Right? What's
I
that?
don't want anybody calling me up going, yeah, I'm calling about the F-150 for sale. Oh God. Yeah, no. All right. So let's jump into this. Got some new stuff for the new year. Hope you guys are going to enjoy this as much as I enjoyed horsing around making it. So before we get into the actual documentation, this is the new Kirk's Law Corner 2020 opening winder. I was having some fun. I thought that was pretty cool.
I like it. And then I just noticed that the big red K.
Uh-huh. Oh, you didn't see that before?
No, I didn't catch it.
How did you miss that?
Because it was all boxed in, and I don't know. I just was looking at the words, and then I just realized there's a big red K there.
Yeah. Well, hey,
That's
your first
awesome.
name is Kirk, and I'm like, I can make that work. I think I can make that work. And then of
Love it.
course, that's me. So we figure, hey, if we're going to follow the law and the rules of the court, we're going to have some fun doing it. We're going to play around with, make sure we do this graphically because, try to help people remember how to do this stuff, right? Best way to remember something is attach emotion to it. And this, we get to say goodbye, say so long to Shift Made Up 2019. Bye. See ya. Say hello. This is hindsight 2020, baby.
That's right.
So everything that happened last year, it's in the taillights and it's now part of the year-end reporting. Oh, this is going to be fun.
Yep. It
So
is.
we're going to bring on another Wednesday Night Live. And with Kirk and I want to just say again, thank you to those of you who have donated, of course, because it really helps us keep this stuff going. Makes everything that we do possible here. And, yes, we want to try to help you guys understand this, put it in such a way that you guys will be able to retain it, right? Still, I don't have anything on the new Masons manual yet. I did send them email today, so I'm waiting to see when that release date comes out, and more importantly, when I'll be getting my inventory. So
I wonder. I just have to wonder here with the new administration and how things have changed a little bit, a lot of it.
right?
That they may have had to scrap the new 2020 build of the Masons manual based on the fact that of these changes. Yeah, I'm just have these thoughts that something may have to change, and there's going to be a delay with the 2020 release.
Well, and again, that's why we said, well, I'm about to get into that here in a little bit. Matter of fact, put in a new special Happy New Year promo code for the Teespring store, by the way. HS 2020 and hindsight 2020, HS 2020 gets you 20% off for the entire month of January. So
Awesome.
Happy freaking New Year. So I put the loss prevention and the malicious designs of men must be thwarted on the front of the shirt and the hindsight 2020 on the back of the shirt. So I thought you guys would enjoy that. Me making fun of the Medicare for all Shift Made Up. This is my way of poking fun at that. And, hence the structure of the Obamacare, whatever the hell you want to call that, cluster bomb. right? So getting ready to cover real property. That's actually what this is going to be when it's done. So, as a licensed professional, those things are periodic audits are, of course, mandatory. But more to the point, getting to what Kirk was just saying about having to scrap or update the new book. Remember, we brought forth some very interesting things to the court, and we said, "Hey, who's watching out for Lady Justice?" Because nobody that we're seeing, only thing we see is a bunch of emoluments breaking the law.
Mm-hmm.
Right? We're not seeing any defense mechanism here. So who the hell's defending Lady Justice and providing for the common defense? Right? Well,
That's a good question.
dating back to the original Continental Congress, which of course we've shown. I'm going to get into that in just a second. Um, I've said, well, hey, that's kind of my job, at least according to everybody that says, hey, I want to play loss prevention too. It's like, what do you mean? How do you not have a loss prevention department? You're running a company and you don't have a loss prevention department? Are you an idiot? So,
Mm.
So I said, what are we doing with corporations? Right? How's all that going to change? Because it's all changing. We already know that. Right? So, in the here and the now, this one's built. So I said, hey, want to play Monopoly Corporation? I'll play Monopoly Corporation with you. Probably not going to like me playing because
Right?
what I know goes all the way back to here. So, you know, starting with the American colonials who were in favor of a revolution decided to use this act to maneuver Britain into a difficult position. Rumors were planted to the effect that the Tea Act created an illegal monopoly. There it is right there. This is the thing that
Back in
created the first Continental
1773.
Congress. Yeah. Pretended acts of legislation, right? This
Yep.
is what this is the part in history that they're talking about in the Declaration of Independence.
Yep.
Pretended acts of legislation. It's right there. So, you know, um, we're going to talk about the law of creation. Well, the law of creation was a pretended act of legislation called this Tea Act, right? So I said this is the part where this country goes through puberty, I guess, for lack of a better expression.
Yeah.
And
Pretty much.
you know, we decided that hey, yeah, this is so old it's new again. What the hell? So uh, you know, so I said, what was the first thing that started the Continental Congress? I mean, it was the merchants. Okay. Early in May of 1774, the Boston Committee of Correspondence sent a circular letter throughout the colonies urging a stoppage of trade with Britain. This appeal was met with a mixed response. In New York, a committee of 51 dominated by merchants. That would be those of us who are incorporated, right? That's the reason that this works the way it does. Drafted a reply on May 23rd. This is the history in the law of creation of why corporations pay tax in commerce. We've been through this like 1,070 times. So, that's what creates these emoluments, right? That advantage, profit, and gain, and how we manage those things, which turned into in free markets, right? Market advantage, profit margin, and capital gain. So, everything that created all of that infrastructure in New York, right? Well, that's what you see right here. This is downtown New York City, baby. The financial hub of hence the reason ACH is there, Federal Reserve is there, blah blah blah. You know why there is such a thing as the corporate veil, right? Let's see. What are you doing with your corporation? Are you building battleships? Are you building roads and bridges? What are you building? Well, this is the law of that creation, and it evolved from those things I just showed you.
Right.
So, the as we know, the word appears in every oath of office, an actual oath of office, by the way, not the fake ones that were appointed, the ones who actually swore to do their job, and actually meaning that they swore that duty of loyalty and all that stuff we went over on the corporate mechanism, or on the when I went over corporations.
Mm-hmm.
Swearing every damn day, everybody does that, but I mean, it is what it is. But split boards of directors, we talked about this on the last show, right? Operations is the Senate, finance is the House of Representatives. you know the finance side goes over to and reports, and the CFO work together, the chief financial officer in the private sector. In the public sector, that would be the vice president. Imagine that. In the public sector, we have the Senate and the president, and in the private side, it's the operations Senate and the CEO. Those things are equal. Imagine that. So,
No.
You got to have your book, right? There's got to be an instruction manual in there somewhere. Here's where it gets tricky, right? Because sole power of impeachment's in the House. The preferred manual is Jefferson's, right? So, of the three manuals, it makes sense to put Jefferson's in the House and Mason's and or Roberts in the Senate, right? So, I mean, either way, however we want to do it, I don't care. I'm a pretty reasonable guy, but we're going to do it, and we're going to do it right? So, I mean, to as far as I'm concerned, I don't want to cross this road in history again. We're sick of this, right?
Right.
So,
It's already been done.
yeah, more times than we care to shake a stick at. Hence
Just
the
needs to
reason,
be followed.
right? So when the court said, "Hey, loss prevention, we want to play too. You stand over there. We want to hear this." I'm like, "Oh man." But I didn't want to play court. Shut up
Right.
anyway.
Well, the court of justice,
Right, right. So, but that is ironically, as it turns out, that's exactly what they said. Well, you've been playing court all along anyway. What are you bitching about? It's like, oh yeah, good point, good point. So, that's why I
Yeah.
said, six of one, half dozen of another.
Right.
One of the reasons that we recognize SMU the way we do, right? I mean, it's this simple. Or at least it was to me. Hence the problem. It's like, how do you not see this? Was kind of my point.
Right.
So
This breaks it down pretty good.
exactly. So what process did I follow to get from where I started to where I am right here? That's what everybody's wanting to know. I get it. I understand that. So kind of like where we're headed to tonight. And I'm going to stop that right there because I don't want to get in and do too much of a spoiler alert on the whole real property side of this, because I'm putting together an entire presentation for you guys on an actual real property transaction. I got those short forms, those kind of, they open up and it's like what, 6 pages or whatever it was. And I scanned those for you guys, but I've got, I'm scanning some of those, just some of those specific sections in, but there's also segments in the law that go with that. So I'm going to put those in context. And she can't do that because she doesn't know what I know in that. So that may take me a little while, but I'm getting through it. But in the meantime, as far as following the law and the rules of the court pursuant to the mandate, so I said, okay, I can do that too. So let's look at what following the law and the rules of the court looks like. I just found this out there on the federal court's website, Middle District of Florida. This is an actual civil case flowchart.
Hmm.
And so starts with everything from the complaint and works all the way down through the process. So, again, you want to make sure that you know the steps and you're taking the steps properly. So, again, now there's a difference. This is civil, right? This is not criminal. This is the civil process. Criminal's a whole different animal. So, because all of these cases, how many times have been sold? Have we been told that's a civil matter? That's a civil matter. Fine, let's talk civil process, right? So,
Well, here's the thing, and we've discussed this before, is there is essentially just one process. It's whether or not it's criminal in nature or
mhm,
civil in nature. Civil in nature meaning that you're only going for a monetary relief, damages, and criminal in nature,
mhm,
that's criminal. It dictates the type of jury.
right,
There's only two types. You got the beyond a reasonable doubt and a preponderance of the evidence.
right,
So,
exactly.
beyond a reasonable doubt is for criminal, which you have to get unanimous consent from all 12 to find guilt, not unanimous consent to find innocence, because an innocent man doesn't have to prove he's innocent,
Mm-hmm.
right? So, this is where they misconstrue how the right to a trial by jury works.
Mm-hmm.
And they go, oh, well, that's a hung jury because it has to be unanimous one way or the other. No,
Mm-hmm.
that's a lie.
Right.
That right is declared in the Virginia Declaration of Rights, June 12, 1776, as it is written under the letter of the law. But the complaint, right? The complaint is a complaint, whether it's civil in nature or criminal in nature. It's
Mm-hmm.
still the same form of complaint.
Right.
You got to
So,
you got to declare what right it is that was violated. What
mm-hmm.
was the conduct that violated that right? Was that conduct criminal in nature or civil in nature?
Mm-hmm.
And then what are the damages?
Right.
That's it. That's the basic fundamental rules of the common law that dictate what the form of a complaint is supposed to look like.
Right.
I didn't write it. That's just the law on how what a complaint is supposed to look like. Those
Right.
three key elements must be in the complaint.
Mm-hmm. So, gonna kind of get into this stuff a little bit, and I'm gonna leave the flow chart up, and as we go down through it, because with each step, you're going to notice there is a possibility of two potential outcomes with each step, right? In other
Mm-hmm.
words, I mean, there are some that don't, like for example, paying the fee and, providing service of process, there's only one outcome for that. But,
Right.
you know, kind of the short version is here before I go into any kind of specific great details on this, you have your complaint. And at that point, you have a choice: pay the fee or motion to proceed without fees, or that's called informa pauperis, right?
Mm-hmm.
So if you elect to pay the fee, you go straight to service of process, right? So now what happens is, if your motion to proceed without fees so happens to be granted, okay, everything you filed is served, right, is referred to the magistrate and served by the clerk, and of course would be by the sheriff, right? Because
Mm-hmm.
that's how it works. This part here, I always tell people, depending on how committed you are. So I always say, if you're that committed, don't be bashful to pay your fees and pay for service, right? One of our biggest complaints that we get is, well, I didn't get service of that. Well, um, did you provide service? Wait, what? Oh God. So, you're going to complain because you didn't get service, but you didn't provide service either. That kind of sounds like a one turn deserves another, if you ask me. So, but in the context of just um pay your fees, provide your service, and and that gets everything to the court. Don't think the judge isn't going to take that into consideration, right? when the case gets before them, they're going to look at it and go, okay, how committed is this person? Does this person just want something for nothing? Or are they committed to this? Are they willing to pay for it? Are they committed to it enough to where they're willing to pay for it? Because, Kirk, you ran a shop.
Mm-hmm.
How many times did you get, you know, people come in just to have the free diagnostic, so they go to the parts store and buy the parts themselves, and you just wasted how many hours of rack time? So,
There's a few. There's
yeah,
definitely a few.
was that fair to you? You had shop expenses to pay.
Well, most of the time, I'm pretty hip to that little con game,
Uh-huh.
and I the way I did it is I don't do free diagnostics. Minimum 1 hour shop rate. If you want me to diagnose what's wrong with your car, I can do that,
Right.
and you'll pay for that
And
because that's contracting my labor. So
exactly. You just,
to
yep.
avoid that
Mhm.
con game of, oh well, I'll just come in for, no, I'll waive the diagnostics if you agree to the repair.
That's right. And that's exactly what this is right here, right? That's
Mm-hmm.
exactly what they're doing, right? If you pay the fees and you provide service, right?
Mm-hmm.
That's exactly what you just got done saying, right?
Right.
You're you're
It's almost
committed
it's
to
almost
it.
like it's a principle.
Exactly. One of those fundamental principles. So I said judges are smart. Don't think you're gonna pull anything over on them.
No.
They've been around a while. They were like me. They were born at night, but it wasn't last night. So
Right.
you notice this referral to the magistrate judge or judge, whatever. See, again, in your process, do you want to attempt to resolve it with a magistrate? You also have the right to request the presiding chief judge. That's exactly what I did. But again, already
Supposed to go
knowing
to the
this,
district court because the magistrate is really only supposed to handle preliminary things.
hmm so I said, look, the preliminaries are already done. I want the presiding chief judge, which is the thing that resulted in the mandate that hangs on the wall behind me, because Judge
Mhm.
Cohen was a presiding chief judge. So he looked
See, and
at
that's
it.
where it says if both parties consent. So all you
Right.
really have to do is say, you know what? I don't consent to this de facto kangaroo court
hmm
presiding over my case.
Right. Right. And I'm getting to that. So what'll happen is if you've provided service and proof of service and da 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 da, okay, and they default, right? They don't respond. If a defendant does not answer or otherwise respond to the complaint, the plaintiff may file a motion for the entry of a default by the clerk. Here's the rule: Federal Rule of Civil Procedure 55A. It's in the rules of the court. So don't take our word for it. This is directly from the court, guys. So,
Right.
and what is a default judgment? Okay. Well, if a default does not cure the default after entry of default by the clerk, the plaintiff must file for a default judgment seeking an award of the relief the plaintiff sought in the complaint if the well pleaded allegations establish a claim and the relief is warranted, right? So there's a
Yep.
burden of proof there, a preponderance of the evidence.
Something I want to point out here, there's a duty in there of the clerk that's being pointed out. It should also apply equally if there is a motion for dismissal made
Mm-hmm.
and there is no answer within 21 days.
There it is. Well, that's why I said I hadn't gotten to the answer part yet. If you want to go ahead and do the answer, by all means, because you're actually really good at this part. So, um,
Okay,
if you,
so
if you want to pick up the answer, by all means, because that takes you right down to the next segment.
right. So your answer has to be in the form of what's called a response, right?
Right.
And some of the key elements of an answer is admit or deny certain each one of those. And this is the reason why we go back to, I talk about the statements of facts, right? In the complaint, your declaration of facts, you want to make them as short, clear, and concise as possible, because each statement, if there's one thing that's off out of that statement, let's say you put in just a little too much fluff, and you overspoke,
Right.
and somebody catches it. Okay, that's what's called a counterclaim. You're doing your counterclaims, and you deny that in there, and you say, well, this is not true. And so that whole claim, that declaration of fact, gets voided.
Right. So
Okay.
this goes
So,
to where I always say, do you want to fight or do you want to win? Right.
right. But this
So
this is how you have to do your paperwork. This is the
right.
proper, pursuant to the rules of procedure. You have to answer.
Right.
Okay.
And this is confirming everything we're telling everybody. That's the part I love about it.
Right. So I'm just going to read what it says here, and then I'll talk some more. The answer is the defendant's response to the complaint. What is your response? Is it a response of admit or deny? Do you have everything that you deny? You have to do a counter claim. Now, if you're actually injured, right? You got damages. Guess what? That's called a cross claim. In your answer, you can declare your cross claims and your demand for your relief, which also you have to pay a fee according to their system. So a defendant has 21 days, or if the defendant is in the United States, 60 days to file an answer after being served with the complaint and summons. Alternatively, the defendant may file a motion to dismiss the complaint for various reasons, like lack of subject matter jurisdiction, lack of personal jurisdiction, failure to state a claim on which relief may be granted, failure to plead fraud or mistake with particularity, improper venue, which is territorial jurisdiction, and failure to join indispensable parties. So, in summary, there, subject matter. Okay, does this court that the petition was filed in, the complaint, is this a competent court having subject matter jurisdiction? Do they have, is this a competent court, say, going into a criminal court, would you have anything to do with real estate? No,
I would say probably no.
that's not a competent court having subject matter jurisdiction. A criminal court does not have subject matter jurisdiction over real estate. That's got to go over here in a court of chancery in the probate.
Right.
Not over here in a criminal court.
Exactly.
Okay. So now for personal jurisdiction, you got the wrong person. That's an all caps name. Or, oh, this is McDonald's versus the state of whatever, or state of whatever versus McDonald's, and it's Burger King. Well, you got the wrong person. We're not Burger King, we're McDonald's. So you served the wrong person. So this is personal jurisdiction. It personally does not apply to you, such as there's no contract. That's essentially what personal jurisdiction is really about, is where's the contract? Because I'm not personally liable for any of this, and I'm going to demand the contract. Full disclosure. So that I may scrutinize that contract. I demand it. Where's the contract that would bind me to this? So I'm going to object to that personal jurisdiction. I'm not a party to any contract with you, and I don't know who you are. Wrong person. Now, failure to state a claim on which relief may be granted goes right back to what I was originally talking about there. The three basic elements of a complaint must declare in the declaration of facts part, which comes right out of that common law pleadings book. This is pursuant to the rules of the common law. Just is how it works. Has worked for over 1,000 years. So what is the right? What was the conduct that violated that right? and what damages did that cause. If those three particular elements or any one of those elements are not in the complaint, it is, in fact, a motion for dismissal for failure to state a claim on which relief can be granted. Or something like, hey, you wrecked into my fence, my neighbor wrecked into my fence, and you know, I want $10,000. Well, the jury can't grant you $10,000 in relief when it only cost $800 to fix the fence.
Mm-hmm.
That's failure to state a claim for which that's fraud. So that brings into that other part there.
What's reasonable, right?
Yeah, that's not reasonable. You can't even prove $10,000 in damages.
That's right. So that establishes what's called a reasonable standard of relief, right?
Yep.
So
So then the next one there is failure to plead fraud or mistake with particularity. Okay. If they're saying that you committed fraud or you had some sort of mistake,
mm-hmm.
okay, well, what is it? What you have to itemize what page, what part of the document that's fraudulent or is a clerical error and mistakes, which that
Mm-hmm.
falls under fraud. We're not
Right.
actually talking about fraud upon the court. We're not actually talking necessarily here in this when we're talking about mistake,
Mm-hmm.
but the fraud part, any kind of fraud, the negative nexus,
That's right.
right? You can make a motion for dismissal for fraud, objecting, right? So motion for dismissal based on fraud, one of the key elements, you can't proceed upon fraud.
Right.
And any man who gives aid to fraud becomes culpable.
That's right.
They become a conspirator.
Mm-hmm.
So, if there's a clerical error and mistake, which you could bring up the all capital letters name, you could bring up the all capital letters state of, you could
Mm-hmm.
bring up even the capital letter S, lowercase state, right? Because in the legislature, as the legislature dictates the proper format
Mm-hmm.
of these documents, most of the states that I've looked at so far, and I haven't looked at every single one of them, but the three of them that I've looked at so far, it is in a lowercase s state of. That is proper form because the lowercase s represents the people. The uppercase s represents government. Well, the government's a fiction and the government doesn't have a right to a cause of action. It's got to be on behalf of one of the people against a public servant. That's the way that's supposed to work. Public law using public courts are to be for prosecuting public servants or those in the public, like McDonald's and Burger King. And you gotta beef, you gotta beef with a corporation.
Where's the beef?
Suits have to be in like kind.
Mm-hmm.
So you use the public court to prosecute damages against you as the man from a
Mm-hmm.
corporation. You have
Right.
to use the corporation that they've been incorporated into and are bound by the public law that
Mm-hmm.
they operate their business in a certain manner, and it cannot be contrary to the Constitution.
Right.
Constitutions is
Mm-hmm.
right in as far as I know, again, one of those every state constitution. I can't verify that because I haven't looked at every single one of them, but every single one that I have looked at has the clause in there that says every corporation who incorporates into the state must be bound to support the Constitution of the United States of America and the state of. Plain and simple.
Right.
So that's business practices must be in accordance with the Constitution itself first. You
Right.
cannot be trespassing upon people's rights. Like, hey, we're not going to allow you to have arms in here. No, you're bound by the Constitution, and it says that right shall not be infringed. You don't have the right to say a man cannot exercise his rights in your establishment because you're under the people, not over. Your policy and business practices would be contrary to the law of your creation.
Right.
And now we get into the improper venue. Like, okay, well, this car accident happened in such and such county, but the defendant decides to go file over in a different county. That's the improper venue because the crime did not happen in that county, which was previously ascertained by law.
Just for those who just joined, Kirk is actually going through this section right here. He's discussing this case management report, case management and scheduling order referral to mediation. So this is the section. This is where most of the work happens. So this is the stuff you got to know, and this is why I was really hoping Kirk would deep dive into this, and I knew he'd be ready to go. So
So that's the improper venue has been translated from territorial jurisdiction. They don't like to use territorial jurisdiction because then that indicates that you're on the land versus out on the high sea or out on the sea, which would put you in admiralty jurisdiction or maritime law, dealing with foreign and interstate commerce in trade. And then you have a failure to join indispensable parties. So let's say that you have the board of commissioners for the corporation, and you fail to incorporate those parties to enjoin them so that they have an opportunity to respond. You didn't put them down on the list of parties, interested parties. It can be done that way as well. So other than that, from there, that's your basic grounds. When you go look at the rules of procedure, they'll have under Rule 12B, 12B6 more specifically, but 12B, Section B, is where all of these are listed for lack of subject matter jurisdiction, lack of personal jurisdiction, failure to state a claim for which relief can be granted is 12B6. In federal rules and most state rules, they've adopted that same format of the rule. Insufficiency of service, insufficiency of process. They violate due process of law. No. As soon as they violate due process of law, that's a motion for dismissal under Rule 12B4, I believe it is. So, a lot of people don't quite understand that if you violate due process of law, you lose all jurisdiction. Plain and simple, right from the get-go, that's fraud. You're depriving a man of a fundamental right, and you don't follow the duty that right imposes, you lose. Plain and simple, that's just how it is. That's how the law works, because the law punishes falsehood. Lex pundet mendiceum. The law punishes falsehood. So
there's
you
also
make
the other one, right?
false in one thing and false in everything.
Right, falsus in uno. Well, that's falsus in uno is a doctrine,
Mm-hmm.
but with reference to due process of law, remember the maxim, right? The process of law is a heavy hardship. The law crowns or rewards the work. So if you don't do the work, how do you expect to get from point A to point B? Right. So, those are those clues that I put in the paperwork all over the place. So, in other words, it's like, look, I get this stuff. What I want to know is why the guy that I paid didn't get this stuff.
Mm-hmm.
I was doing this stuff for big companies. What was he doing here? And the answer is, you guys already know the answer to that. But,
Mm-hmm.
you ready for me to highlight discovery or motion practice yet? Or are you still into,
Yep.
okay, what
Pretty
do you want
much,
to do
I didn't
next?
really go into once a complaint has been filed, the clerk will enter the track notice setting deadlines, right?
Mm-hmm.
That sets everything on track in
Right.
motion,
Right.
right? In most cases, the parties or counsel of the parties is, if represented, must meet and prepare a case management report. The
Right.
report addresses discovery, scheduling matters, Based on the case management report, the assigned United States Magistrate Judge or United States District Judge will enter a case management and scheduling order that governs deadlines and dates in the cases. And we're talking about that mediation there. This is that notice and opportunity to be heard before you go to trial, right? You're trying to come to a resolution here. Okay, look,
Right.
yes, I admit these ones and I deny all of this. And I'm going to demand strict proof in accordance with the rules of evidence that you come up with evidence to support your claims. And a lot of times they will do all this fluffy stuff to get you frustrated and pissed off a little bit, and get you out of your element. And what you got to do is you just ignore their false statements and say, well, I deny all of that and I'm going to demand strict proof. And in fact, here's my counterclaim. That's actually not true. In fact, this is what is true. And you force the showdown. And what actually happens here is you're whittling down to actual facts that they have evidence to support those claims to make it truth. Okay.
Yeah.
So once you get down to those basic elements of what's actually true and provable in court in front of a jury, that's when you start going to the mediation and going to the table and go, okay. Yeah, I did wreck into your fence. Hey, I didn't do it on purpose, but you're entitled to have me compensate you for fixing the fence or whatever we can come up with. And that's just because he is entitled to have his fence repaired that I wrecked. Okay. So if we come to a resolution, all right, hey, I'll help do the fence and I'll pay for the materials and we can work that out. Or you know what? I'm not doing shit for you, but yeah, I'm responsible. I'll pay for it and I'll pay the full 800. Okay. One way or the other, that's mediation in a nutshell. And you come to a resolution and you stipulate. You do a stipulation and everybody stipulates to this. And the judge says, hey, did you, it has to be in writing.
That's right.
And both parties have to be present and say, yep, we stipulated to this stuff in here. This is exactly what it says. And we both stipulated that. We both signed it. That's a legal binding contract.
Right.
Everything is a contract in the end with all of this, believe it or not.
Right.
So other than that, if you want to dispute things, then it's up to them, to the moving party, to prove beyond a reasonable doubt or a preponderance of the evidence, which is 3/4 of a jury, must give their consent to find guilt. That's it.
There
Now
you
want to
go.
get into the discovery. Okay, request for discovery. What do you got over there? You're claiming you have all this stuff. So I'm going to demand your proof. Right now, give it over. And no denial of exculpatory evidence. Now, here's a key here, is the fact that it seems that, oh, well, the defendant, we're going to do a motion for discovery on the defendant. No, burden of proof is on the moving party. The, Fifth Amendment, the innocent is innocent until proven guilty.
Yeah.
And you do not have to give any information that may incriminate you yourself. So
that would be the Fifth Amendment.
Right.
Yes. Just making
Yes.
sure.
The fifth, pleading the fifth. That's the most common. I'm pleading the fifth. But no, they cannot compel you to give up any information that may, indicate your guilt.
Well, that would
But
be
the other
called a
side
what?
does have
Yes.
to give up any information that may indicate your innocence.
Right. Because
Yes.
that would be a fishing expedition. And can they do
Bingo.
that?
Let's make all these false statements, and we're going to do a request for discovery on the defendant. And you need to produce all this stuff so we can see if we can actually find what we're looking for.
Yeah.
Because we don't actually have the evidence. See, this is the problem. They're supposed to have the evidence before they make the complaint.
Right.
You're already supposed to have that evidence, that right to a cause of action.
Right.
Before you file the complaint.
Mm-hmm.
Not like in today's timing of, oh, well, I'll just file the complaint and we'll do an investigation and we'll see what we can come up with.
Yeah. Mm-hmm.
That's not how it's supposed to work.
Right. Well, here's what's actually happened. Those investigations are now coming to fruition that they ordered, and now it's coming to pass that there was never a cause of action. Here's the part, here's where it really gets ugly. Now the state is on the hook, right, for liability, right, because of the actors in these prosecuting offices, these emoluments, right?
Mm-hmm.
So they come out and they make all these grandiose claims of everything from, you know, you mean, rotten, miserable bastard to, why don't you just charge me with the Kennedy assassination while you're at it? I mean, what the hell? I mean,
Right.
yeah, I mean, it's just, if we're going to do it, let's go for the gusto.
Now,
So,
there's certain things under discovery. Let's go back to McDonald's as an example here. Let's say, you're the plaintiff and suing McDonald's,
mm-hmm,
and McDonald's is now the defendant, and we're asking for their business license, their policy number, their insurance carrier, and
mm-hmm,
their terms and conditions of their insurance policy. That's within the scope and authority to demand from the plaintiff, from the defendant, because they're a corporation. They're required by law to have that. The Constitution dictates that they have to have that.
uh-huh,
So that's part of their business practice. In order to become a business acting in interstate or foreign commerce, that's required. We, the people, require that so that we can what? Alter, reform, or abolish anything. The capital T thing would be the business license or
right,
corporation, because again, that's a thing.
right.
So,
Or establish liability if there is liability or culpability, right?
and that's where I was just going to go, was if they're at fault and they're liable, does their insurance company cover that? And
Right.
this is where we have a little misunderstanding, I believe, out there about, well, I'm going to go after their bonds. No, the insurance company doesn't cover stepping outside of their scope and authority of their emolument. And so when you do go and get their insurance company, because this is essentially what I'm leading into is arbitration here,
Mm-hmm.
the insurance company will not cover damages for under their bonds if they act outside of the insurance policy. It always says in there, we will cover this, we'll cover this.
Mm-hmm.
Here's what we don't cover: acts of God, blah, 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 blah. There's always that clause in there of all those things that they don't cover.
Right. Hence the old school workman. My argument against workman's comp claims. You know, workman's comp does not cover stupidity. If you act like a dumbass, right, and you get yourself hurt, don't expect the company to pay for that because the company didn't say it
They
was
weren't
okay
at
for you
fault.
to act stupid. Yeah,
Right.
there's no culpability there, right?
Can you,
So
yeah.
don't expect the company insurance to pay for your stupidity. Don't do that, right?
You were
So
hired to perform these specific duties. Can you show me in your employment contract where we said that you can go do stupid shit and cause injury to yourself?
yeah,
I don't think any corporation out there, anybody who runs a corporation in their right mind would put that kind of clause in an employment contract.
right, exactly. So
So
that's why I said, these judges are pretty smart. They've seen people pull crap like this over the years. So, obviously, when we have to go in and, oh, yeah, we were the guys that processed all of that garbage, we were the ones that were actually writing the defenses, not these idiot bar members, by the way. So they actually got to hear it coming from the horse's mouth for a change. And it was like, well, that's not what we've heard in the past. Well, what did you hear in the past? Well, here's the examples of the stuff that we heard in the past. Well, no wonder you're having a problem. No, none of that is accurate. So, because these idiot bar members, they pay each other off, right, to pull their shenanigans. Nothing is ever brought properly before the court in your defense, right? Hence the reason, like we brought it up in the Twin Peaks case. right? Remember,
Mm-hmm.
defense counsel had the prosecutor on due process violations.
Yes,
All
she
she
did.
had to say was he acted outside the scope and authority of the emoluments of that office. And
Yep.
that case would have been over right
Hammered
there
right there.
because it wasn't brought proper before the court, right? The court could not make the decision, no matter what the judge felt about it, because it doesn't matter what their feelings are, right? It's only what's proper before the court. So, you know, when it was like, well, yeah, I know how to bring things properly before the court, which I'm going to get into here real shortly. It's, you know, that's the reason that we wanted to cover this flow chart tonight, because this is really important that you guys need to know this stuff in following the letter of the law and the rules of the court, which is
Yep.
exactly what my mandate says. So, you know,
Now, something I was just reading here under the motions box there.
mm-hmm.
I did not actually know this, but this is great to know this. Any party may file a motion regarding discovery or other issues. Before filing most motions, counsel for the party filing the motion or the party filing the motion, if unrepresented, has to discuss the issue with counsel for the other side or the party on the other side, if unrepresented, to determine if the issue can be resolved among the parties without court intervention. Most issues are resolved in this manner. Holy crap, I did not know that.
Imagine that.
Before you even file a motion for whatever, you're supposed to contact the other side and say, hey, I'm thinking about filing this motion over here. Do you want to try and resolve this without any court process? Gee, that would save money and time, wouldn't it, on all parties,
Right.
including the court?
Exactly. Because,
So why isn't this being practiced?
thank you. Because they're so arrogant, they don't think they have to talk to us. They've convinced themselves, they are believing their own bullshit, that they are superior
But
in
it's
that
in their
fourth
own
pillar.
rules. Didn't they go to law school to learn the law?
Now
What the
you know
hell did they go
why.
to school to learn?
Now you know why I wanted to
Good
cover
Lord.
this tonight, right? you, you say, well, look, here it is in the rules, even in the federal rules, civil procedure, rule 5, rule 7B, civil procedure 10, 12, local rule 3.01, and local rule 3.01E or G. So, if you can point to the rules and specifically what the chart says, when you go in and you file your motion to the judge and you cite these rules, right? That, look, I attempted a meeting, okay, pursuant to the rules of the court, and they wouldn't, there was going to be no communication, right? So this is why I said, give you guys everything I can possibly give you to help you arm yourselves. And, so cite the rule, right? When you
Yeah.
file your motion
Uh-huh.
pursuant to Civil Rule of Procedure 5, whatever 5 says, if that's the applicable one. Okay. Um, you know, you go through and you put your motion down, you run, you state your language in your motion and why. Okay. In a conclusionary statement of some form, you can state in the motion or in another document supporting your motion.
Mm-hmm.
Attempted meeting with counsel that went unanswered. Right. So all you have to be able to do is to show that you reasonably attempted resolution. And if you were ignored and treated arrogantly, like, yeah, we already know that. Okay. Um, if you don't find it in the Mason's manual, I'm sure you'll find it somewhere in a court rule, which is why when I construct these briefs that are based on the court rules, right? Even the lawyers are picking this stuff up going, I know what this is, and the judge is going to know what this is if he gets his eyes on it. Oh God. So, you know, that's why I said, don't be bet. Reading means reading. This is the stuff we're talking about right here.
Right. So this
And
goes back to the fundamental principle of due process of law, notice and opportunity to be heard.
right.
So, it's right there in writing, right? This isn't something that you put together. This
No,
is something they put together, and you
this is from the
found this
federal
diagram.
court. This is the federal court.
Yeah, right straight from
Highest,
the federal court.
right. The highest law, Supreme Supremacy Clause, and the minimum due process. So if your local rules don't at least provide for this, that emolument is broken. It's deficient,
Bingo.
right? So
Hierarchy.
there you
So
go.
there it is. You're supposed to communicate with the other side before you take any action. And it, technically
Right.
speaking, is supposed to be in the private. And
Mhm.
there's proof positive of it right there.
How many times have we said this, Kirk? How many? It's supposed to
Thousands.
be in the private, right?
Thousands of times. I know for a fact I've said it at least 1,000 times or more over the last 4 years.
Yes, exactly.
In the private.
Right. So here it is. Don't take our word for it. It's in the court's flowchart, even giving you the rules, for God's sakes. So, when you do take it and you appeal to a higher court for these sham shit show processes that we know they're doing, right? All you need to be able to do is reference obviously the constitutional provision, the process in the Mason's manual, as I'm going to go through, in the corresponding court rule. That's the
Yep.
rule of threes: the letter of the law, the rule of law, and due process of law. Right there,
Yep.
you just nailed all three of them. And that's why I said, when I go into this after we're done with the flow chart, this is going to make total sense to you guys, or at least I hope it will. So,
Right. So to discuss that Federal Rule Civil Procedure 5, which I encourage people to go read, is I thought Tony Pellegrino was full of shit when he told me you have to give them notice in the private, a lawful notification letter, before you even do the summons and complaint.
right.
That's what Federal Rule Civil Procedure 5 is all about right there.
Right.
You have to afford them the opportunity in the private to correct what they're doing wrong before you claim your right to a cause of action and sue them. That's what Federal Rule Civil Procedure number 5 is about.
So I'm going to see if I can pull that up.
And that's right there in that O'Connor's Federal Rules Civil Trials.
Yep.
And I started reading that. That was right after I
clicked on the wrong damn
Tony
thing.
Pellegrino. And I'm like, no. And he's like, no, for real. And
so let's go down through that, because here it is on the court's website, right here, right? This ties the local rule 3.01 to Federal Rule of Civil Procedure 5. So let's go down to, where is it here? I know I saw it a little bit ago.
G. Right up just a little bit. I don't know if
Up a
that's
little
what
bit.
you're looking for. Before filing.
Yep, there it is.
Yep. Before filing any motion in a civil case, except a motion for injunctive relief for judgment on the pleadings, default judgment, for summary judgment, to dismiss or permit maintenance of a class action, to dismiss for failure to state a claim upon which relief can be granted, or to involuntarily dismiss an action, the moving party shall confer with counsel for the opposing party in good faith effort to resolve the issues raised by the motion, and shall file with the motion a statement certifying the moving counsel has conferred with opposing counsel and stating whether counsel agree on the resolution of the motion.
There it is right there. So remember, we didn't make this stuff up, guys. I mean, this is from the rules of the court. So if anybody tells you that, we're making this shit up and we don't know what we're talking about, here it is. It comes directly from the court. right? So
And
when
that's
the court
absolutely
says to
right.
me, hey, follow the law and the rules of the court, I'm like, well, yeah, dude, I can do that. So, you know, they're like, well, why can you do it? They can't. And I'm like, well, that's a good question. So, you know, hence the whole what emolument allows them to do that, right? So, but and of course, when we get into the rest of these things, you have your dispositive motions, your final pretrial conference, right? If you couldn't resolve it civilly in the private, you can have a pretrial conference, right? And then, of course, you go to trial, judgment, and then if you're going to take it to appeal, you take it to appeal. But that's the flow chart. That's it right there. I mean, this is on one page, guys. you know, keep it simple, stupid. Right? How many times have we said that? Keep it simple. So, is there something else you wanted to add before I go into any specifics in what one of those would look like? Because I'll stop if you do. If there's something you want to share real quick, I'll by all means have at it.
No, I think we're good there.
Okay.
Might go back to that.
You want the rule up or do you want the PDF?
The PDF there, the diagram.
There it is.
So dispositive motions. After the period for discovery, it may appear that the facts are undisputed, and any party may file a motion for summary judgment. The judge will decide if material issues of genuine fact must be decided at a trial. If the motion is granted on all claims, there will be no trial, and the lawsuit will end. Right. To
Right.
narrow the issues at trial, a motion for summary judgment may request summary judgment on fewer than all claims.
Mm-hmm.
So if they have sufficient evidence, okay, you've admitted this, this, and this, but you're not this, this, and this, that over there,
Mm-hmm.
you still go to trial on those other things. So you can grant summary judgment on some things and not on the others, and can still go to trial on those other deals.
Right.
Right. That's not so clear cut and dry evidence,
Mm-hmm.
right? It's questionable, or, well, you got to have the testimony of two witnesses to the same overt act, and you got one.
Yeah.
Well,
Doesn't rise to
doesn't
the
meet the
level of
minimum
criminality.
standard.
Right. So if it doesn't rise to the level of criminality, who's liable for what's already happened? So you have to know the civil process, right? Because you're going to say, well, they drugged me through this entire sham and shit show, right? Well, and there was no proof of anything. Well, how do I fix that? Well, that's what we're doing here tonight, right? Is, you know, they broke their own rules. They blah, 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 blah. Well, what rule? Well, I just know they broke their rules. If you can't cite the rule and where it came from, why? What do you want them to do? There's nothing they can do for you. So,
Well, they're the ones that are supposed to know the rules.
no. Well, yeah, the attorneys and the bar, in the everybody in the bar, yes, absolutely.
The judge sitting on
But
the
I'm talking
bench is
about,
the one that's supposed to know the rules. We're not supposed
well,
to actually know the rules. We're just supposed to know common sense that, hey, this doesn't seem right. Well, yeah, that actually violates rule number blah 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 blah.
well, what
They're
do
the
we
ones that are
know
supposed to
about
know the rules.
somebody? Well, remember, you have that of the three elements, advantage is the most critically abused one. So the way to remove their advantage is know what they know. So when you go into Congress and you lodge your complaint, right, for oversight, you'll be able to say, according to Federal Rule of Civil Procedure 5, we were supposed to have a conference and that never happened. So why was my appeal dismissed? Right? So because they're not used to people knowing how to call them on their sham and their shit show the way we do, right? We know at least as much, if not more, than they do. And that's going to get me into what more we know than they don't know, which is
Mhm.
going to lead us right into this shortly, but once we finish with the flow chart. So you go down the flow chart and you can say, you know, in under final pretrial conference, right? Where was the what was a defect there that happened? Or what was a defect that happened in discovery, right? Well, that would be a Brady violation. There was exculpatory evidence that was withheld. Well, what rule in the court could you cite to do that? Right? Well, here we go. Federal Civil Rules of Civil Procedure 26 to 37, and of course, local rule 3.03. So if you don't know the rules, the rule of law, then how are you going to go in there and cite that this thing is broken or it is defective, right? You can't tell them that they don't know their job if you don't know how to do their job. Hence the reason in loss prevention, I had to know everybody's job. You have any idea how much of a pain in the butt the loss prevention really is to do? So that's why I said,
So,
you know,
I want to
hello, welcome to my work.
Right. I want to interject something here because this totally destroys the whole Arbitration Act.
Right.
So, where in this process do you see arbitration? I see mediation. Now, arbitration actually subverts the law and deprives you of your right to a trial by jury.
Correct.
Because then again, this is taking the power of the jury, that right, away from the plaintiff to take it to a trial and get consent from a jury to find them guilty. That's how it subverts the law, your rights.
That would be a usurpation, correct?
That is. That's an usurpation of power by Congress because Congress doesn't have the power to make law. Not like that.
They don't
not
have
public
the power
law.
to make.
That's a congressional act. It's not law.
Right. It's pretended acts of legislation.
It is pretended acts of legislation.
Correct.
So I'm sorry to those of you that just thoroughly enjoy arbitration and that kind of stuff, but it was done up by the banksters, the corporate entities that said, hey, we're tired of getting our butt kicked in a trial by jury. So let's come up with this arbitration stuff and we'll subvert the law and we'll take away the right to a trial by jury. And you have to come sit over here and supposedly a disinterested third party presides over your arbitration.
Right. But
and I'll make the decision whether there's grounds for to pay out damages.
Yeah, sure.
No, I don't think so.
That's not due process of law. So,
nope.
So to
and
get
again,
into
this is where we get into Congress doesn't have the power to make due process of law.
So the second page to this, by the way, this is only 2 pages, is actually the long, it's in larger print, so you'll be able to read it. And it also does have, and I am going to post this out there, by the way. So, this will have, like, for example, what Kirk was just talking about, dispositive motions, right? We're just talking about Brady violations under discovery, right? And of course, everything up to and including notices of appeal. So, but this is the blow up of everything you see in this chart, right? So this flow chart gives you the examples of what the possibilities are, right? If you don't follow the process correctly, right? So, do they have the right to charge you a fee? No, they don't have the right. But does it get you from point A to point B faster? Here's what happens. If you're in the right and you know you're in the right, why the hell do you care if you pay the fee or not? Because you're going to get it back.
Right.
Right. So if you know this,
if you prevail, you get your costs and fees back.
Exactly. So you're not.
And the loser pays them.
Right. So in essence, you're not paying anything. Right. This is a test. Right.
Yeah.
Are you correct? Do you believe you're correct enough to make the investment, right?
Yeah.
To run the process. Well, if you don't believe in yourself enough to just go ahead and pay the fee, like paying for Kirk's time in a diagnostic, then you're probably a bullshit artist somewhere. And I would expect as a you know as a business professional, somebody who's been doing this a long time, I can tell you that's one of the 7 danger signs that I know somebody's trying to pull a sham on me. So,
Mm-hmm.
you know, if you believe in what you're saying, you're willing to invest in it. So, it just, I mean, it is what it is. So, you know, hence the double edged sword.
Right.
When you pay the fees, you're in the driver's seat. Because guess what? You just went straight from pay the fees right to the referral to the magistrate. You get to skip all of this.
Yep.
So that is a benefit to paying the fee, right? You don't have
Oh
to
yeah, this
go
this guy's
through
serious.
this.
He paid the fee. He's ready to go. Let's do this.
Yeah, right? If
Yep.
you're serious and you want them to know you're serious, right? It's like investing in the stock market, right? If you're going to be serious enough to invest in the stock market, um put your money where it's going to make you money. I mean, it is what it is. That's investing in yourself, right? So now let's get into this. I actually did this. This ended up in quashing the most recent shit show that the Florida Department of Revenue tried to pull. And basically, kind of the short version is the appellate court come out and said, yeah, you know what, you're right, it's moot. So but anyway, here's how we got there. Okay. I filed the notice of appeal. I went in and basically all I had to do was put the information in the document. So this is so simple, it was stupid. Comes now the Office of Loss Prevention by and through the cited mandate of this court acting qui tam under the U.S. Code as Private Attorney General Christopher E. Howell, CEO, citing lack of standing of counsel to proceed with her motion by the Florida Supreme Court's order dated March 14, 2019, in the form of this motion, citing page 25, section 16 of Due Process of Law, as articulated in the Mason's Manual of Legislative Procedure as follows. Now, the reason that I did this is because this is due process pursuant to the Sixth Amendment, right?
Mm-hmm.
So that's why I said, if you're going to argue fraud and bad faith, what did I just say about follow the law and the rules of the court? Follow the law and the rules of Congress. Remember, you're
Yep.
pleading not just to the court, you're pleading your case to Congress. So when they get this in oversight, right, the oversight committee is going to go Mason's Manual. Open that up, page 25, section 16. Does that say what he says it said right there? Yep, sure does. That means they can verify that claim,
Yep.
right? It's that simple. Don't make it more complicated than what it is. So, moving on to the next section here, Florida Constitution, Article 1, Section 9, double jeopardy and self incrimination. Section 10, bills of attainder and ex post facto law, citing Title 4D as Sharia law. Non disputed allegation violating Article 4, Section 4 of the Constitution of the United States of America as follows. There's the Constitution, right? That's it
Yep.
right there. So, what did we just nail? We just nailed every bit of this in the opening statement. Hence the reason even the court was like, you know what, you're right, this is moot. Get this shit out of here. So, you know, they know full well what we're doing, and they know full well why we're doing it. They know that we didn't want to do this because here's me saying, you can't act on behalf of my ex-wife. That's in error. You jackwagon, you don't have standing to do that.
Yeah.
So
Who are you?
yeah, leave her alone. Quit screwing around.
And say they
So,
do this. They do this on their own volition without
uh-huh.
without the other party's consent or even notice. They just
Well,
file this stuff and say we're doing it.
right. See, so they count on the fact that, oh, well, we're going to make them fight and he or she won't think about the other side, right? We're going to play them against the other. Well, again, the old man was born at night, but it sure as hell wasn't last night. so, so anyway, moving on with this, because this
Yep.
is, this is, like I said, this was a stout document. Previous dated emoluments violations by this department. Whoops, sorry. By this department of the Florida Constitution, Article 1, Section 11, no person shall be imprisoned for debt,
Hmm.
receipts on file in DC and in this proceeding. This action is being pursued, further violating due process of law as follows. Section 517, action must be within power or vote is ineffective, right? Well,
Hmm.
because you morons, somebody up there decided you were going to pass this Sharia shit while I was at work. Guess what? There's two criteria for that. No motion or measure is in order that conflicts with the Constitution of a state of the US Constitution or with treaties of the United States. And if such a motion or measure be adopted, even by unanimous vote, it is null and void. Due process of law was violated while I was at work all day. I knew where to find it, shoved it in the paperwork, and said, and oh, by the way, you can't even make a rule that does that because the rule would be void. So I cited that as
Yep.
well, right? So follow the law and the rules of the court, which is exactly what I did,
Yep.
right? So this section has the clear effect of rendering these star chamber proceedings void for any effect as bad faith, being only one of the two requirements of Section 16 cited above, and gives rise to a cause of action to expunge this case, citing Motion 39 to expunge through due process of law in the legislature, clearly outlined and available for the department to inspect at their convenience. The test case was Owen versus City of Independence. They
Yep.
want to play stare decisis? No problem.
This
Right?
has already been previously discussed and decided on.
Exactly. That's right. So,
So
again,
no need to make any arguments further. No all arguments are moot. It's already been
that's right.
discussed.
That's exactly right. So, this is fighting in essence, not just for Lady Justice, but this was in essence following due process of law as it's written. So,
And the crazy part, you were going in and defending your ex-wife.
oh God. So that's why I said this is almost so much fun. It should be a crime to call it work, right? So as this case has been proper
If that ain't being a good ex-husband, even if you hate each other, come on now.
right. Well, anyway.
I gotta pat you on the back, brother. I gotta put you up there.
Thanks,
Hey,
brother.
this man defended his ex-wife even when he didn't have to.
Well, actually, yes, I did, because
Well,
knowing what we were up against, this was
right,
not her fault, right?
right,
So, you
right.
know, because I saw it for what it was, and even though I know she couldn't, right? So I had to be the better man, right? This is what we just
Right.
keep saying.
Yep.
So as this
You did
case
real good. I love
has
it.
been properly removed to the quorum, citing Florida Constitutional Article 5, Section 2A as follows: the letter of the law,
Say it isn't
right?
so.
The Supreme Court shall adopt rules for the practice and procedure in all courts, including the time for seeking appellate review, the administrative supervision of all courts, the transfer to the court having jurisdiction of any proceeding when the jurisdiction of another court has been improvidently invoked, right? A court of incompetent jurisdiction doesn't have the power, right? So this is where the letter of the law says that, and a requirement that no cause shall be dismissed because an improper remedy has been sought. What was my remedy that I requested? Expungement. Leave her the hell alone. So tell me how that's an improper remedy. Pursuant to due process of law, to Washington, D.C., citing this dispute between the states of Ohio and Florida being properly executed, documents attached in full disclosure, this office is continuing in the constitutional oversight quorum as mandated by the 5th District Court of Appeals, granting this office standing in that process. Here it is right here, citing page 563, section 795, number 10, as follows. An investigation into the management of the various institutions of the state and the departments of the state government is at all times a legitimate function of the legislature. Period. We have preached this for how long? So, you guys want to know how I've pulled this off? This is how I did it. So, Florida Constitutional Article 3, Section 11 and 15 specifically cites divorce as not lawful as it is classified with prohibited special laws. The question becomes, how can there be a court or practice that is repugnant to the law of this state? More specifically, an unauthorized practice of law under Florida statute 454.23. Seems like a simple argument to me. So, guess who else agreed with that? So, just saying. And of course, the bullet case, remember, this is in that memorandum of law that you guys have all seen this. So, citing the enforcement and violations of the Hobbs Act, because we are in jurisdiction to that market advantage, profit margin, and capital gain in the commerce area, right? So, they're violating the commerce clause. Here's the body of law. Excuse me, bring the body, right? Well, here's the body of law that shows what the violations are and how they are codified. So that's why I said they want to play code with me. Oh God, this is not going to end well. So the various cited violations contained within the attached document or documented processes as a result of unlawful enforcement of the documents obtained through an unlawful process are under this article subject to oversight and submitted through the remonstrance slash parliamentary inquiry processes as required by constitutional law, henceforth only to be construed in this process as supporting documentation for this claim to grant this demand for cease and desist, which is exactly what they did. So, any department processes against any acting agent or principal client of this office before Congressional Oversight Committee, see 28 USC 1443. There it is. Very simple. And of course, that ninth principle of group decision making, right? How are you going to properly cite fraud or bad faith? Okay, well, must be no fraud, trickery, or deception resulting in injury to another member. This is why I said this is injury by fellow servant. Why? Because crap, I have emoluments of my own. I'm a fellow servant. Sit down there, bruh. You got a problem. So a person is entitled to protection of the courts from injury through injustice by a body making a group decision as in any other situation involving injury. As I just articulated, even the appellate court said, you're absolutely right. This whole sham is moot. You're
But
right.
But again, we reiterate the word there, a group decision.
Right.
By a body making a group decision.
Right.
As in any other situation involving an injury. So
that's right.
That's that
Principle.
quorum. The jury is the quorum.
Right. So let's go
You're
back
in the
up
wrong.
here.
You're not a group.
Yeah, you're not of competent jurisdiction.
That's right.
Right. So
that's what's called de facto, without fact of law.
Right.
That cannot exist in our form of government.
Right. So you want to use the republic to smack them back down into where the hell they belong. This is exactly how you do it. Right. Cite the letter of the law, the rule of law, any rules of the court that would apply. Right. You know, this is why we joke about it. Reading means reading. It is what it is. So, you know, it's
comprehension goes a long way too, you know.
Well, you know, I mean, just saying. But to be able to go in and cite, oh, by the way, when Congress screwed this up, here's what they violated in the emoluments of Congress, right? Remember, to know a thing and to be bound to know it are regarded in law as equivalent. So this is your subject to the emoluments of Congress. What in the absolute hell are you doing? Right? This is how you go in there and you smack them around. So the argument, right? Very simple. Citing Title IV et al. As Sharia law, I am not bound to it as as my constitution guarantees me a republican form of government, citing due process of law when I have a grievance with government in any form, now being able to articulate which pillar of law her membership card is to be attached. This clarifies first the many differences between her bar card and my business license as not being in like kind. There it is, right there. I am incorporated into the first pillar of law, subject to the oversight of the people of the United States of America at all times, and I acknowledge that my service could be called upon at any time, excuse me, to provide any and all subject matter knowledge with respect to this word, as my office is the only one in recent history to test it as a defense contractor in the federal courts, orders appendicized, blah, blah, for full disclosure, da, 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 which of course everybody knows that. And I'm perfectly fine with that, as I've always been throughout my career. Right? This is me saying, you want to bring it? Let's go to work. This is me exercising my right to work. So, however, wait a minute. However, she is incorporated into the fourth pillar of law outside of the three pillars of the Republic, making her bar card an emolumentum or benefit card, such as relationships are not lawfully established in law, only at law, making them foreign emoluments under Article 1, Section 9, Clause 8, as now indicated by the dictionary. See Foreign Emoluments Clause. Right there. Whammo.
Yep. Yeah.
This difference also clarifies the inherent conduct of her practice being monarchy in both character and form versus my practice being fiduciary, republican in character and form. Our processes of pleadings and practice do retain certain similarities, but our duties are very different in format. Counsel's is that of a statutory duty, which is fundamentally flawed upon review of history, those easy emoluments of statutable plunder, and the Federalist Papers, in context of the Judiciary Act of 1789 and why the founders wanted it to be separate and apart from the other two branches, yet keeping it the smallest of the three branches of the republic. There's the law, the history of law, the facts of law, blah, 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 blah. And of course, where I came out here in this case, it was just decided on June 10th of this year, right? Where here it is. The court here proceeds from the presumption that the government is not a person authorized to initiate these proceedings absent an affirmative showing to the contrary, right? Leave the woman alone, damn it. Because if I have to come up there and break my sixth pillar manly firmness foot off in somebody's ass, somebody's going to be having a bad day. This case being recently handed down also clarifies the reality of the state cannot be a person with access to favorable procedural devices, further confirming unlawful use of the emoluments of the Attorney General's office and departments. I'm sorry, lack of standing, to say nothing of jurisdiction, which they clearly do not have either. So, my conclusionary statement, unlike the monarchy mentality of the bar and its lack of willingness to do its job, loss prevention will do the job and supply tools to the court consisting of much greater capabilities than stone knives and bear skins in the performance of its fiduciary duties of defending Lady Justice against all emoluments, both foreign and domestic. You want my oath of office? There it is, right there.
Yeah.
So, and of course, attached is notice filings, page 69 through 59 through 65, Mason's manual, which I will go through here real quick. Yeah, certificate of service, right? You got to have that certificate of service, right? Who got it? Judiciary Committee, Florida House of Representatives, Ohio House of Representatives, and opposing counsel. Imagine that. So, oh, and of course, Ashley Moody's office got a copy of it via electronic service because that's what the rule says. So, here it is, section 71, chapter 8, page 59. Here they are. We've been over these once or twice on the show ish. So, specifically, right? The people, the power under the powers of the court, section 73, right? The court doesn't, they have to acknowledge it when you put it in front of them. They have to acknowledge people of each state are vested with sovereign authority expressed by their elected representatives. Expressed by their representatives serving in a legislature. Thus, legislative power is absolute and unlimited, except as restrained by Constitution. So, what I cannot do in my person, I cannot do through the agency of another. Right? Pretty simple. Judicial notice in support of appellant's motion. So I said I had a little fun with this. So just so you guys know, comes now the Office of Loss Prevention, all that other stuff that we already said, blah blah blah. The court will take judicial notice of the fact my special appearance is at the behest of the children's mother. Actually, more of a command from her to me uh, to come in here and figure out how this department has been stealing her money and getting away with it. Now that I look back on this, so hey, I'm not afraid to go in there and speak it like it is. I mean, it is what it is. So the court will also take judicial notice of the etymology of the word emolument and notice the difference between the dictionary definition on page 638, Black's Law 10th edition, right? Credible source, as positive proof as to why counsel lacks standing to present her motion to enforce or any other motions as follows, right? So this is where I went in and I cited an emolumentum, right? Well, there are four elements. She cannot articulate where that bar card is registered. That's a private membership only club. So there's only one lawful explanation. That means that's a benefit because it doesn't fit in advantage, profit, or gain, but that benefit gives her an extra advantage, profit, and gain over pretty much everybody else that walks in the door. Can somebody explain that to me, please? Um, 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 Yeah, that's what I thought. So that's why I said, knowing that advantage and where that advantage comes from as an extra benefit that they have that you don't, right? Well, me exercising my advantages from the first pillar of law, right, representing the people of the state of Florida as private attorney general, right, saying, no, you don't have that power. Your ego just wrote a check your butt can't cash. Sorry about your luck. Take your monarchical crap and get the hell out of here. So here's the actual definition from the 10th edition. As I said, I always put it in there, right? Don't just go in there and say it. Writing means writing just as much as reading means reading, right, bro?
Mm-hmm.
So we can now clearly see the differences between emoluments, three elements: advantage, profit, and gain, versus its 13th century root word emolumentum, four elements: advantage, profit, gain, and benefit. These differences also clearly lay out these entitlement programs as stipends versus subsidies as we do business in commerce. Crafty, I'll give them that much, but not crafty enough to get one by loss prevention. Be so advised that Christina and I don't agree on much these days, but there is nothing we loathe more than scammers, thieves, corruption, and liars. So, uh, so far in this shift made up sham, that's all I see dealing with scumbags like this in my daily career of investigating, catching, and ultimately prosecuting this garbage. Probably why I love my job so much because as you can well see, I'm really good at it. So,
Right?
you know,
And you are.
well, again, that's why I said you don't get into doing this job by, you know, being an idiot and screwing up, right? So, I mean, it is what it is. So, in accordance with the Attorney General William Barr's answer to my parliamentary inquiry into the quorum during his congressional or confirmation process, his use of the word stipend instead of subsidy is also clear and convincing evidence these entitlement stipends are, in fact, practicing barratry as defined in the Rules of Professional Code of Conduct governing the Florida Bar and its members. Wham! so, so I said, you don't want to play Monopoly
Mm-hmm.
Corporation with me, you son of a bitch. I'll tell you right now. Ooh, I hate that. So, let's see here. Let the official record reflect that my office takes serious issue with any person or entity that acts not only in contradiction to the law of the land, but has itself and its members convinced they are not accountable under it as equal citizens of the United States and residents of the state of Florida. Yeah, I'm telling them exactly. So I said, you guys were saying it, and I said, you know what? They're saying it. I'm thinking it, so I'm going to say it. This type of conduct can only be outlined as the conduct of tyrants outlined in the Declaration of Independence, and subsequently why my remonstrance petition clarifies this private club using that conduct as a checklist of things to do in these cases. So,
Hmm.
does it any of this sound familiar?
Yeah, it does.
uh,
When did you write this?
well, this was what this went in November 26th. So you'd say it would have been probably close to the end of November when I wrote it.
Yeah.
Um, as this office conducts audits among other services, I have also created what we call in the private sector, a quadratic litmus test, and we've been through that. We just went over all of that. So, as this court is undoubtedly aware, the word law is actually an acronym, citing the Testamentary Trust from 1666, land, air, and water, and go through all the history, right? From FDR's administrating, adopting these multitudes of new offices, harassing our people and eating out their substance, da 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 da. Right. So again, that's why I said this, the whole, to go through and explain this, to get to the end of this here, again, lawful principles researched for this motion, right? What is your research, right? Where did you get it? What source? And is it credible? How many times have we said this? So this is me practicing what I preach. So, I mean, it's very, very, very simple. This particular segment is actually from my 11th edition. And then, of course, as is this, right? They want to talk fiduciary duty. Let's talk fiduciary duty, right? I know all about contracts. I got a license for that. So, again, why I sign in blue ink, right? As a contractor. It is what it is.
Yep.
So, and then this is actually very short. I just called it a question, classified it as a petition for a writ of quo warranto. Come to find out, it wasn't even necessary because of everything that's been going on. So, it's been because getting answers from these guys was, you know how this is. It's like pulling teeth, right? So, I believe these are posted out there. If they're not, let me know and I'll make sure I get them posted out there for you guys. But kind of the short version of this, in so much as the treason clause appears in Article 3, Section 3 of the Constitution of the United States is concerned. This let's see. This should say this presents the potential question of establishing proper locus jurisdiction to hear these cases. So I forgot an S. Sorry. 50 lashings with a wet noodle.
How dare you make a clerical error?
Hey, right? Yeah.
Mistake.
So he missed an S.
A typo.
My God.
It's a typo.
Shut up. My fingers hurt. These emoluments being clearly foreign in nature in violation of Article 1, Section 9, Clause 8 of the Constitution of the United States, the missing 13th Amendment, does present the potential of invoking the Uniform Code of Military Justice and the JAG as being the proper locus jurisdiction for such cases upon review of historical documents, Supreme Court rulings, and world court decisions already established as potential support for this question. Right? So, as a defense contractor, this office does retain certain clients with respect to unlawful transactions of real property, up to and including crimes against humanity, and such referrals or opinions from this court for the purposes of direction of these cases would be helpful, as this court does possess oversight authority over any potential actors with relative involvement in these cases. Right? So, in other words, I'm saying, look, I am acknowledging your proper lawful authority, right? You got actors that act within the scope and authority of the emoluments of your office. I get it. So if they're practicing this crap, right, go in there and kick his ass. Guess what's happening. So, that's exactly what they're doing. So, but you have to bring it proper before the court. Well, again, if you don't bring it proper before the court, how are they going to act on it? So this is why I say, one of the reasons why it was like, okay, well, you want me to follow the law and the rules of the court, pretty much what I've always done all day, every day. Say that again. So, yeah. So I hope this is Oh, yes, I am clerically. I'm clearly in the. I love you too, Malika. Says, well, Chris is clearly an idiot for making mistakes. Yeah, for make mistakes and clerical errors.
Right.
Oh God,
It does happen.
yes, once in a while, Oh, he missed an S. Oh my God. So anyway,
Yep.
so I that's what I said. I hope that kind of clarifies a lot of the stuff for you guys out there because, you know, I've been busy all month long. You guys know that. That's why I said December is hell month for me. So to be able to finally come out and put all of this together with the year end recap from Monday Night Law, leading up to what just happened here recently and why, and that's why you know we're pretty much washing our hands of all of this crap. And but you know I'm one guy, I can't do it alone. Kirk's one guy, he can't do it alone, right? So you know to give you the benefit of all of our knowledge, hell yeah, we'll definitely do that. That's the reason we do the show. So I hope it helped you guys to be able to see the verbiage from the book in context of an actual document. So, I know sometimes, you need the example. I got to see it, So I get it.
Mm-hmm.
And, oh, yes, my back hurts. Been just extremely busy. But,
Yeah, I was actually looking over here trying to find I seen it the other day.
mm-hmm,
I believe it was an executive order. Trump kicking the bar out of decision making on appointment of judges.
right,
He recommends, right? So there's some I can't seem to find it right now. I can't remember if somebody sent it in to me in a message or
right.
where I got it, but I remember popping it open and reading it. And
Mm-hmm,
I'm like, holy crap, there it is. Holy crap.
yep,
I mean, I knew
yes,
that, Trump had gotten rid of certain things.
mm-hmm,
And yeah, I was trying to freaking find out where the heck that was at.
right. So, yeah, I had it. I wonder if it's in this on this machine where I can put the link to the site.
Yeah, dang it.
Um,
I wish I would like immediately save those. And I usually do stuff like that. That's kind of pertinent. And I try to save it right away
right.
before it gets lost in email or messages or where I don't know.
Mm-hmm.
I know that somebody sent me a link to it.
I just responded an email to that very question, and I'm trying to remember which browser I had open because I got stuff like everywhere. Well, here's the one from April 24th of 2019. Executive order on transferring responsibility for background investigations to the Department of Defense. I'm going to shove this in the comments. Excuse me. Because at the very least, this will link you guys to the very website where we get our information. So, wanting to make sure that everybody has all of this stuff.
Right. But the deal is that the bar is on its way out, and Trump just got rid of the power that the bar had sitting at the table there, going, "Well, we don't approve of the appointment of this man because they're not competent because they're not a member of the bar or whatever." And from what I understand, that with all of these appointments, or not Trump. See, I know that Trump doesn't appoint them, right? He submits them for approval for appointment, right?
Right.
And the Senate is the one that approves them.
Mm-hmm.
But the thing is the bar was coming in between there and saying, well, we don't approve of these guys. We don't approve of them. We don't approve of them. Well, we approve of this one over here. They've been a longstanding member of the bar. See, this is how they've been controlling the judges in the judicial branch. And Trump said, nope, no more, dude. You're not interfering with our Republican form of government.
Nope.
That
not anymore.
process doesn't exist in our form of government. You're out of here.
Right.
Plain and simple.
So again, when we walked in with due process of law pursuant to the 6th Amendment, well, actually the 1st to the 13th original amendment, if we're going to talk amendments, right? So, I always say, what process are you following? Because that crap doesn't exist in my republic.
Right.
The only lawful process I'm aware of is the one that I do at work all day long, every day. Bring your quorum. If you don't have a quorum, we're out of here. You didn't follow due process of law, dude. See ya. And this is what the bar wants. They want to be able to go in there and just put everybody on tribunal because they say so.
Yep.
What did we say the other night? We don't have lords in this country. They have to go have their spot of tea somewhere else because we don't have lords.
Yep.
Oy, oy, oy. Oh.
Good old Magna Carta.
Well, again, the quorum evolved from the Magna Carta. The quorum process evolved from that, right? That's evolution, succession of law. So, but, it is what it is. So,
yeah. It is what it is.
mm-hmm.
So now that we're all aware of this corruption, the question is what are we going to do about the sad state of our republic? Are we going to start claiming and exercising our right to all political power and our right to alter, reform, and abolish anything at any time we deem it necessary? And are we prepared to instruct our representatives to perform those specific duties?
Under those emoluments? There's the word. There's a word. We found it.
Under the emolument of their office.
Right.
The office, the emolument dictates the scope and authority.
Right. So,
and we the people create that emolument by constitution.
Right. So in other words, it's okay. Well, what is the process? Got it. Right here.
Yes.
So.
Yep.
I don't object to doing this. Insisting that we do this the right way.
I mean, let's just go read, because reading means reading. And let's see if my computer does the screen share like it should. So this is my Idaho Constitution, right? Article 1, look at that. It says Declaration of Rights, Bills of Rights, Declaration of Rights. This is laying down the law, because law is that which is laid down, ordained, or established.
Mm-hmm.
So, justice to be freely and speedily administered. What does this say? Courts of justice shall be open to every person, and a speedy remedy afforded for every injury of person, property, or character.
Mm-hmm.
And right and justice shall be administered without sale, denial, delay, or prejudice. Courts of justice. Courts of justice are in the House and the Senate. The judicial branch has courts of law and courts of equity.
Mm-hmm.
No, it's still not picking it up, is it? Dang it. YouTube is
What?
not seeing the screen share.
Ooh.
That's weird. What the heck happened?
You
We
broke it.
used to work on this machine. That is so weird.
Well, I saw they were.
I know it's working on Facebook just fine, but
Yeah.
YouTube, sorry, hang in there. Article 1, Section 2 of the Idaho Constitution. Political power inherent in the people. All political power is inherent in the people. Government is instituted for their equal protection and benefit. What does that say again? Government is instituted for their equal protection and benefit.
Mm-hmm.
And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. I did not write this. This is law. Declarations declare the law. This is laying down the law here. We have a right to the administration of our government. It is our government. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. This is why we have to go to the legislature to remove their immunity from being sued.
Uh-huh.
That's the law.
Right.
This is how our form of Republican form of government works.
Uh-huh.
Now, we'll go down here to Section 10, right of assembly. The people shall have the right to assemble in a peaceable manner. To do what? To consult for their common good. So we have the right to call them into assembly peaceably so that we can consult for our common good. And guess what we get to do once we do that? We get to instruct their representatives. That's right, because we have all the power. They are servants. They only get to exercise the powers that we delegated to them, and we have to possess those powers first in order to delegate that power.
Mm-hmm.
And to petition the legislature for the redress of grievances. This is, in fact, how our Republican form of government is supposed to work. We don't go to the judicial branch for this crap. We go to the legislature as it is
Anything else is, well, it's a
the letter
usurpation.
of the law.
Yeah. Anything else is a usurpation or potentially a violation of due process.
Bingo.
So, I mean, unless you're talking about something like a small claim, you know, which I would think a small claim, grow up. You should be able to handle that without a freaking small claims court judge. I mean, really? But, you know, there are the people that like their Judge Judy courts just because they are addicts of Judge Judy, or I mean, whatever, you know. But, you know, the simple fact is, um, you know, when we have to come out and we have to do projects like this, extensive projects like this, I mean, you know, that's why I said it's just like, okay, well, you know, how would I do this if I were at work? And I'm like, okay, well, here's how we do it at work. Well, that's how they're supposed to be doing it. Why aren't they doing it? Don't look at me, dude. I was at work all day long. So, you know, that's why I said it was just like, oh, yo, 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 yo. Oh, okay. Now I get it. Which, of course, explains everything as to why every problem that ever got heaped into the friggin' company always managed to come across my desk. And it was like, you know, walk in, oh, I got a clean desk today. Next thing you know, 5 minutes later, me and my big mouth. So, you know, Yeah. The other
All
thing
right.
too I want to caution everybody about is, remember, we joke about the word salad. You know,
Yeah.
if it sounds,
It's a salad of words.
yeah, well, if it sounds funny to you, like if somebody were to walk up to you and say something, don't put it in your paperwork. Follow the law, the letter of the law, and the rules of the court. You know, that's how you get into this kind of shit made up, this sovereign citizen crap, which, you know, I'm glad it was only like $6 because I'd have been really pissed if it would have been any more than that. I mean, I'm definitely going to be posting some of this stuff as an example of what not to do. So, um, you know, I always say stuff like this is dangerous, and I always use film, right? Like movies, film, like, like entertainment as a good barometer. Anybody's ever seen the movie series National Treasure? Okay, whether you like Nicolas Cage or hate him is irrelevant. The storyline, right?
Right.
One of the things that makes the storyline so, I don't even want to use the word believable, but plausible, is that Independence Hall is a thing. Liberty Bell is a thing. Silence do good letters, the Federalist Papers. Those are all things. I mean, those are real things. So it's how they tell the story that surrounds the real things is what you need to be careful about. So knowing the difference between fact and fiction, right? That's
Mm-hmm.
um, you know, this is again having to unlearn some of those things you've learned that you were strategically programmed with, right? No, there's no, or what is that, Ottendorf cipher on the back of the Declaration of Independence. I would bet my last bottom dollar on that. So, I mean, come on. Yeah, it was a great story. It was a great movie, but, you know, just know that it's the difference between fact and fiction. So,
Yep. All right. Well, we're we're just past 2 hours anyway. We were a little bit late, but
yeah, we're
hope
middle
you
of a
enjoyed the show tonight, folks. Thank you for your likes, follows, shares.
Mhm.
Make sure you do the thumbs up on YouTube and get subscribed down to Kirk's Law Corner YouTube channel there.
Mhm.
And
Also,
much love to everyone out there who is giving aid and support to us. I greatly appreciate it. Keep it coming.
you betcha. As a matter of fact, I'm going to, before we go, thank you for reminding me about that because I'll just go ahead and put that back up again.
Or I could just give up and go back to turning wrenches or doing something else.
Right?
Uh, but I have a very strong, compelling voice behind me telling me that I need to do this.
Yep.
That our nation is in dire distress.
Yep.
So that's
Uh,
why I'm here. I'm trying to help educate the people, trying to learn
mhm.
myself at the same time. I
Mhm.
don't claim to know everything, right?
Yep.
So anyone out there tries to say, "Well, Kirk says he knows everything." Nope,
No,
I
I
never
don't.
claim that I know everything.
Me either. I
No
make
man shall know it all.
right. I make
And
those clerical errors and mistakes. Hell, you guys just witnessed it tonight. 50
right,
lashings with a wet noodle.
right.
Right.
I don't
So,
have a problem admitting that I'm wrong, that I've made a mistake. But
no,
make sure if you're going to claim that I'm wrong, make sure you bring the evidence to support your claim, so
right.
that you know, with a little bit of logic and reason here, I can go, "Oh crap,
Yeah. Well, I
I
thought I was
guess I
wrong
am
once,
wrong."
but
I don't have a problem with that. So,
right. Hey, I thought I was wrong once, but I was mistaken. So,
right.
don't forget, new promo code HS 2020 gets you 20% off through January, all the way this whole month, right? We're getting rid of shift made up for 2019. This is 2020, baby. Hindsight is 2020. right? 2019 is in the taillights. Bye-bye, shift made up. That includes this garbage, right? We want to get rid of this crap. So, again, this is what their Medicare for all looks like, right? Know what to watch for, get ready to deal with it, etc., etc., etc. So,
Yep.
thank you
Good
again for
stuff.
everybody who has donated and all of those wonderful things you guys have done. I will have this real property presentation ready to go, hopefully before too long here, but that's why I say it's going to be a long one. So, um, have your notepad ready, and I'm sure I'll be having to upload that into the the Dropbox, and sending out to my regular email list of everybody who wants access to the Dropbox for all that information. So you guys will have access to all the slides and all that stuff out there. So unless you do screenshots, those of you who like screenshots, that works well too. So however you want to do it.
Yep.
We're going to open up the show after show. Was it 843? I'm sorry, 848-973-346 for the after show. I don't know how long I'm going to hang out tonight. I'm going to hang out for a little while, but
I'm probably not going to hang out much, but we'll see.
Yeah, I got some stuff with people out there who've been chomping at the bit. We got a couple things to iron out, so we'll do that in the after show. Thanks again for everybody for tuning in. Get ready for Friday night fun night. Got a few things ready, geared up for Friday night fun night. So I think you guys will enjoy Friday night show. So
cool.
848-973-346, Malika. There, I'll go ahead and type it.
Typo?
Right? Happens. I guess it would help. It would help if I'd put the cursor in the thing, so when I type, it was actually typing.
Yeah.
That was just an O, like not even a type.
Two different keyboards and two different mice over there.
Right.
I do that sometimes. I'll click on it with this mouse and start typing with the other keyboard.
Right.
Why is it not type? Oh, and see, for me, I have to look at the keyboard. I have to look at my fingers to type. So I'll type all this stuff out, then I'll look up and go, oh, crap.
Yeah, or, I'm doing that a lot too. I'm typing over here thinking it's going on to this machine going, shit, got to go over here and type. So, yeah, it is what it is. But I type without looking most of the time. So, if you guys end up seeing, what do you call that? Computer code pop up on the screen. That's just me working here in the background as we're talking. So, whoops. Wrong keyboard.
Yep. All right. So thank you all. Much love to everyone. And we will see you Friday night for some fun on Friday Night Fun Night.
Thanks, everybody. See you then.
Much love. Have a good night. Happy New Year.
You got that